Hello, thank you all for tuning into the webinar today. My name is Alicia Wolf. I'm an advocate and a planning specialist with the ARC Minnesota. I support families in knowing guardianship, what the options are in guardianship, and doing future planning as well. So please don't hesitate to ask any questions that you have. There's a question box on the GoToWebinar here. So if you have any questions throughout the presentation, I'll try to keep an eye on that. So go ahead and enter those questions there and I'll answer throughout, and there will definitely be a time at the end that I'll be able to answer questions as well. Just a few pieces of housekeeping. This webinar will be available on YouTube after this presentation. The ARC Minnesota is based out of St. Paul, Minnesota, and all of the guardianship information that I am giving to you today will be applicable to really anybody at any stage in their lives, and also you can use across the nation. The laws and regulations that I'll be sharing are specific to Minnesota as well, so keep that in mind. Also know that if you have any questions at all, if you want to talk to anybody after the webinar, please call me at the ARC Minnesota. The direct, or my name is there, all the contact information. You can email or call and get routed to an advocate to speak about guardianship issues or anything else that you're coming across. So again, my name is Alicia. I work with the ARC of Minnesota, and today we will discuss guardianship options. So as I'm sure many of you know, the ARC Minnesota is a nonprofit organization. We started as a grassroots organization from parents that wanted more for their kids with disabilities. Instead of sending their kids to institutions back in the 1940s, they decided that they wanted their children to live at home. And at the time, there weren't any services. So parents got together, rallied around each other, and created the ARC, which helps people advocate for services and supports in the community so their children with disabilities could live their best life possible and get all the support that they needed. And really, that's still what we're doing today. We work really hard to make sure that families have all of the knowledge that they need to be able to provide the best lives for their children and get all the information that they need. I say the ARC is like a first-stop shop for anything disability related. So these are all the ways that we can help. Of course, many, many more. We serve people from birth to end of life, and we support people in a variety of ways. We have Ask an Advocate, where you can call or email questions that you have, and an advocate will get back to you. We do a lot of work in education and IEPs and supporting people through employment, knowing their options with government benefits and guardianship and healthcare assistance. We actively support people in getting onto medical assistance and Social Security. We support people in housing and finding housing and knowing their options of housing. And planning for the future. So we really do a lot of things across the lifespan that supports people in knowing their options for disability services and really where to turn. A lot of times people say that they have a lot of questions, but they maybe don't even know what the questions are. They're just feeling like something's missing. So this is an area that the ARC can support families in. You can call in, you can just talk to an advocate to see where maybe the ARC can be of a support. Additionally, our planning services is something that I like to talk about during this presentation, because I find that when families are considering guardianship, they're also thinking about bigger picture future. So planning services are how we support people in thinking about their future and planning for their lives ahead. So Future Life Options is our all-encompassing future planning program. Future Life Options started back in 2006 when families were coming to us and saying, I'm the sole caretaker for my son or daughter with a disability. What happens if I pass away, or if I'm no longer able to act as a caregiver? So Future Life Options helps people write down all of the information in their brain that they know about their children and how to support them. And then also thinks about who's going to be there, who's going to be a support, and thinks bigger picture of what does my son or daughter want? What makes a good life for them, and how can I work to make sure that they always have the things that make a good life for them? So Future Life Options is our all-encompassing future planning program. We also talk about wills and trust within there, which is a whole different webinar that is on our website currently if you would like to learn more about wills and trusts. Additionally, we have the Transition Vision Program that's specifically for students that are transitioning from high school to adult life. So the Transition Vision Program really breaches the question of, okay, I'm graduating from high school, what's next? I know that I want things out of my life, but I don't necessarily know how to get there. So the Transition Vision Program is support and planning specifically for students leaving high school and entering into adult life. Person-centered planning is a general concept where we believe that everybody has an opinion on what makes them happy and what a good life is for them, and it is our duty to listen to people and to honor what is important to them and what they want out of their life, while also helping them plan and making sure that they have the supports to succeed. So person-centered planning is a great tool at any transition in life, or at any time if you just want to move forward or think about those next steps. The Get Set online tool is it's kind of like an app where people can put in their preferences and what they want for their future of employment and housing. And this is geared towards high school students, where it's maybe the first time that they're ever thinking about what they want for their life. So that Get Set online tool is a great resource. And then the Transition to Adulthood Future Planning Workbook is specifically for caregivers. A lot of times I hear from parents that when their children are 17, 18 years old, that there's a lot of things to consider in that time, like Social Security and medical assistance and guardianship, and the whole transition is very overwhelming. There's a lot of things for people to consider in that time. So the Transition to Adulthood Future Planning Workbook is a self-led workbook that caregivers can purchase to support and guide them through that time where there's a lot of different things that are presented to them. So it's an opportunity to make sense of all of the different opportunities that are out there. As well, you can call me at any time and I can talk to you, or sit down in person with you and talk to you about all of these different planning services and what could potentially benefit your family and your loved ones. Again, just a friendly reminder, that question box, please feel free to enter in any questions that pop up throughout the course of the webinar. When applicable, I'll answer them on the spot. Otherwise, there'll be time at the end for question and answers. So, guardianship. As you have all heard, guardianship is a resource to people that have an impediment in making decisions on their own behalf. And usually guardianship is brought up to families that have children with disabilities when they turn 18. A lot of families have this first conversation in an IEP meeting where the teacher or the IEP team will say, have you ever considered guardianship? Or do you know what guardianship is? And then have the conversation of whether or not it's needed. Historically, our society and our culture has really supported guardianship for people with disabilities, because for a long time, people with disabilities have been put under guardianship to support them in making decisions that we don't believe that people are able to make on their own. That narrative is now changing. There's a lot of opportunities for people to get help in decision making without doing guardianship. So guardianship is just one option. I'm not here to say that it's a good option or a bad option. I am just here to educate everybody on the options that people have in supporting loved ones in making decisions. So typically guardianship happens when a person turns 18, and if they are incapacitated to make decisions on their own, then a guardianship can be put into place. Now, a guardianship is a substitute decision-making process, which means that the court would take away the rights from an individual and would put those decision-making rights on somebody else. So it's literally taking rights away from somebody and putting that on somebody else. Again, that's not necessarily a bad thing inherently, but that's a really big process, which is why it's a court process. It goes through a judge, and you have to prove the need for a guardianship. And again, it's just one way to help somebody in making decisions. For a guardianship to be approved by a judge, you have to prove incapacity in one or more areas of life. So this means that a person is literally not able to make a decision in one or more areas of their life. Not necessarily that they're making bad decisions, but that this person can't make a decision. So a person doesn't know that a decision needs to be made, or a person isn't able to know all of the options to be able to make a decision. Again, not a bad decision, but the incapacity to make a decision at all would lead to the necessity of guardianship. Again, this is just one option, and that's what we're going to talk about right now. I already mentioned that it's based on a finding of incapacity in more than one area, and it's not necessarily an easy decision to make of determining the need of guardianship. It can kind of be a balance, like the graphic is showing here. Is this the best decision for my child? Yes or no? What guardianship is for one person can look different than what it is for another person. So when you're talking to friends or teachers, what works for one person isn't necessarily going to be the best option for another person, which is clear because we're all individuals, and that is the purpose of this webinar. So it's, as mentioned as well, it's not a one-size-fits-all store per se. What works for one person in guardianship isn't going to work for the other. So as I'm going to explain all of the options, know that you can pick and choose what specifically is going to work for your loved one. So you can take pieces of what I'm telling you and kind of hodgepodge it all together to make one support system for people. Before we go into the actual act of guardianship, I want to talk a little bit about less restrictive alternatives. So what we mean when we're referring to less restrictive alternatives is that basically anything that's going to support somebody in making decisions that's not going to court and that's not removing that person's right to make decisions. Because a lot of people with disabilities have the capacity to learn how to make decisions or to be able to take those steps themselves without removing that right. I mean, if we think about myself when I turned 18, the decisions that I was making at 18 were very different than the decisions that I'm making now, much later on in my life. And this is because I've had the opportunity to learn how to make a decision and to make a bad decision and to learn what the repercussions from that decision are and how to adjust within that. And I get by with a little help from my friends. I have a lot of people in my life that I can turn to. And that's one of the first less restrictive alternatives, is a circle of support. So these are the people that are in our lives that we can turn to for help in making a decision. I like to use the example, if you were to go to the doctor tomorrow and the doctor were to tell you that you need heart surgery, you wouldn't be making that decision completely on your own. You would talk to the doctor, you would talk to the nurses, you would talk to your spouse, you would talk to your siblings, you would talk to anybody else in your family who maybe has some information on a medical and has a medical background, because that's the people that we can turn to. So that's, as common sense as that seems, that can be a less restrictive alternative. And in a more concrete way, you can make a supported decision-making agreement. So let's say that you want to sit down with your child and make a list of all the decisions that they possibly would need help in making. And then you would say, okay, so for questions about housing, you can come to me. And for questions about a job, you can go to your aunt, because that's an area of work that she's really, really good at and that she does for her job. So you can make a supported decision-making agreement that's like a written contract that's not necessarily a quote-unquote contract. I use the example sometimes when I turned 16, a lot of my friends were driving their family's cars. And one of my friends had a contract with her parents that said you can only drive between the hours of 7 a.m. and 9 p.m. and you can never have more than 2 friends in your car. That wasn't legally binding per se, but that was an agreement that she knew that she had the guidelines for and that she could talk to her parents about. So a supported decision-making agreement is much of the same in that these are the people that you can turn to and the support that you can get. And that's a less restrictive alternative because that is a way for people to get support in making decisions without having it go through the court process and having that legally taken away. Informal supervision is much of the same. It's having people in your life that are going to watch out for you in certain areas. A power of attorney can be a less restrictive alternative. You can create a power of attorney to act when a person needs it in a specific situation, or to act overall. So a power of attorney can be for financial matters, it could be for general, it could be for medical decisions, and you can use a power of attorney as a more agreed upon and respected contract. That's, again, not the whole process of going to court. And we do recommend that you work with an attorney in creating that power of attorney, just to make sure that it's hitting all the bases that it needs to, and it's offering you and your loved one the protection that it needs to as well. And we have a list of attorneys that specialize in guardianship that I'm more than happy to send to anybody who reaches out to the ARC. So please feel free to reach out if you'd like that attorney list of attorneys that specialize in the area of guardianship, because they can help you with the guardianship and they can also help you with these less restrictive alternatives. Additionally, there's a healthcare directive. We actually recommend that people, regardless of guardianship or not, complete a healthcare directive, because it's a wonderful way to have a discussion of what you want your healthcare decisions to look like in the event that you're not able to make that decision actively. So this gives the person the opportunity to say what decisions that they would want a loved one to make. Additionally, let's say that somebody definitely does need guardianship. We recommend a healthcare directive for them as well, because this gives the parents and the caregivers and the families an opportunity to think about what those healthcare decisions should be when everybody is in a more calm state of mind and able to have that conversation. Because the decisions you make in the hospital when it's a more stressful decision would maybe be different than the decisions that you would make when you're at home having a quiet conversation about it. A living will is a less restrictive alternative, because anybody who has things that they want to give away can do this through a will. So that's a less restrictive alternative, because alternatively a guardian would be the one to make the distinguishing choices in where a person's belongings would go, whereas a will puts that right on the person. A representative payee is a good option for people who want to help their children manage finances, but maybe the only finances that they have coming in is money from Social Security. So if money is coming in from Social Security and that's really the only income that a child has, or that your child has, a representative payee could be all the support that they potentially need. So let's say they're getting $700 of Social Security a month, and that's the only income they have, and your main concern is helping your child with finances. The rep payee could cover that support, because the rep payee, that means that Social Security is going to send the rep payee, so you, the check for that money, and then it's your responsibility to help your child manage those funds as well. A joint bank account can be a wonderful resource, as well as an ABLE account, which there's also a webinar on our website for the ABLE account. The ABLE account encourages people to save up to $15,000 a year without that, and that first $15,000 a year is not counted as an asset to Social Security. And an ABLE account and a joint bank account encourage people to participate in their own finances, and thereby learn how to manage a budget. Because again, if you don't have the opportunity to practice it, then it really impedes your ability to learn it down the road. A special needs trust is additionally a resource, as well as a supplemental needs trust. These trusts are a way for a person to safeguard a large amount of money, or for a family to give a person a large amount of money without it affecting their government benefits. One thing that's not on this list that's a great less restrictive alternative is an authorized representative. So with medical assistance, if you want to help your child access medical assistance and help them apply and help with everything that goes within healthcare, you can be a person's authorized representative. And this is basically just a release of information specifically for medical assistance. And so as an authorized representative, you can do everything that a person could do before before their kid turned 18. So I'd highly recommend that as an alternative to guardianship, because it still allows you to support your kid in their health care and healthcare access. So those are a few less restrictive alternatives. You could use a few of these in lieu of guardianship. You could use them along with guardianship. You could use them primarily. A lot of times when I talk to families and they're telling me that they're maybe waffling between doing guardianship and not doing guardianship, I say perhaps start with a less restrictive alternative. Perhaps start by having your child sign a release of information which is another thing that's not on this list. That's a great one. A release of information that you sign for the doctor's office, or you sign for or your kid would sign for their teachers, so you could still talk to school. You could start by doing that. You could start by seeing if that's enough support, if that's a good level of support that they need in helping making decisions. Because that release of information would allow and encourage you to still have that communication and still guide your loved one through decision making. And it supports them in learning and growing within that decision making themselves. So later on down the road, the hope is that we learn and we evolve as humans and are able to make more of those decisions down the road on our own. So just know that you can adapt these and you can change these and you can use these. And again, if you're waffling between doing a guardianship or not, you could perhaps start for the first 6 months or for a year by trying these less restrictive alternatives, by seeing if they work. And then if they don't work, you can always go back to court and you can talk to a judge and get a guardianship later. And that would be even more proof to a judge that a guardianship is needed if you've already tried these and they haven't worked for whatever reason. If your child's about to turn 18, know that you don't have to do it right away at 18 if you're not sure it's needed. You could wait 6 months, a year, 2 years. It's really, guardianship is based off of the need, and it's not really applicable to a timeline at all. So those are some less restrictive alternatives. Any questions that pop up, please type them in the box and I'll get to them as is appropriate. This here is a supported decision-making agreement. I know that that's really, really small and almost impossible to see on this screen, but you can kind of see that it's basically just a written casual contract. So it has the person's name, it has who they want to support them in what area. And if you can see there on the left, it says yes or no, and then it has a list. So this is, I want help in making decisions about food, clothing, and a place to live, my physical health, my mental health, managing money. So a person can mark yes or no, and then they can assign somebody who they want to help them in those areas. So this is a supported decision-making agreement. This, I think, is the one I pulled this from Texas. So Texas has this actually in their legislature, in their statute, as a legal supported decision-making agreement. Minnesota doesn't have one quite yet, but that doesn't mean that we can't use their form or a form that looks somewhat like this. Minnesota is working really hard right now. The ARC is pushing an agenda forward to create more supported decision-making options for people, so that people just know that there's more options than just guardianship. So there's an example. If you wanted to use a supported decision-making agreement, supporteddecisionmaking.org is a wonderful resource of how people are making supported decision-making how people are making supported decision-making agreements work for their families. You can also reach out to me directly, and I can give you the link to this information. Now, let's say you go through the process of having a conversation with your family and you've looked at all of the less restrictive alternatives and you have either tried or you know that your child needs a lot of support. Again, it's no one right decision or wrong decision, and if you need help in contemplating that, you can call the ARC and I can give you some tips and things to consider. But let's say that you have to move forward with guardianship. Know that guardianship, again, isn't a one-size-fits-all process. So these 7 guardianship powers lay out what powers a guardian has in decision-making. Now, guardianship powers are distinctly different than parental powers. So it's not like your parental powers are your powers as a parent extend once you get guardianship. It's a distinctly different process. So if a person has full guardianship, then that means that they need a support in all areas of the guardianship powers here. But there's also the option for a limited guardianship, which is where a person may need help in making some decisions, but not all decisions. And this can help somebody get the support that they need, while also have the personal self-determination to continue to learn and grow in other areas of their life. So you could have a conversation with your child and potentially only take powers 1, 3, and 5. And the rest would be the individual's still power to make decisions of that area of their life. So to walk through these a little bit, the first power of guardianship is determining place of abode, where a person lives. Now, this is the guardian's power to determine where a person lives. Even so, let's say that you are going to set up to support and set up an apartment in Minneapolis for your kid. That would be your decision and power as guardian. And if your child doesn't want to live in Minnesota, it's still a guardian's responsibility to listen to the hopes and the dreams and the personal preferences of the person under guardianship. Because all guardianship decisions have to be made in a person-centered way. And this is something that the court is going to look for in determining a guardian and doing the annual reporting as well. Number 2 is care, comfort, and maintenance. This includes the need for shelter, nutrition, access to services, including academic and vocational services. So number 2 really covers the guardian's power to make decisions about a person's academic and vocational supports. So this is going to school, this is job coaches, this is working with voc rehab services, this is choosing a DTNH, all of those little pieces. So a lot of people are interested in the care, comfort, and maintenance power of guardianship because they still feel it is a necessity to manage their child's IEP because their child maybe is incapable of managing the IEP themselves. Now, keep in mind that if your child is one to turn to you and to say, hey, I don't know how to make the best decision here. Can you help me? Maybe that's a reason for you to not take that power of guardianship because they're actively wanting your input and they wouldn't push you out of that decision as much as they want your input so that they can make the decision themselves. So if you want to do guardianship mostly so that you can stay involved in your child's IEP, know that guardianship isn't the only way to do that. You can still continue to be involved in that process because you can still be a part of your child's IEP goals and a part of their team and supporting them in that as long as they were to invite you to the meeting. Number 3 is reasonable care for personal effects, clothing and furniture. So this is, as guardian, it's your responsibility to make sure that a person has a winter coat in the middle of February when it's negative 20 degrees, or that that all of the items that they have are safe and they have what they need in that regard. Now, this number 3, reasonable care for personal effects, if you are doing a limited guardianship where you're picking and choosing different powers, this can be one that is often left out for parents in doing limited guardianship because often as a parent or as a loved one, you're going to make sure that your child has good personal effects regardless. And this is an area that people are usually able to manage or get support in managing on their own. Number 4, medical or other professional care. This is exactly what it says it is. So this means as guardian, it doesn't mean that you're required to go to every medical appointment, but it means that as guardian, you have the decision-making power in what doctors a person goes to and what the dosage of their medications are, and what meds they're on, and what therapists they're going to. Please note also, though, that if you were to take this power of guardianship, this would mean that you have that decision-making power. You don't necessarily have the power of the follow-through. So you could set up the best, the most qualified therapist in Minnesota for your child, but your child would still have the right to not show up to the appointment or to refuse to speak to the person. Same with medication. You could work really hard to get a doctor to prescribe a medication that your child needs, but it's a completely different process to force that person to take that medication. So just keep in mind that these guardianship powers really are within the area of the decision making and not the execution so much. Number 5 is approval or withholding of contracts. So this means that any contract a person signs is not technically valid unless it has the guardian's signature as well. This would be a lease on an apartment, it would be a lease on a car, it would be a credit card, anything that is contractually obligated. If a guardian has this power of guardianship, it would only be valid with the guardian's signature on that as well. Now, this is distinctly different than co-signing. So if you were co-signing on an apartment, that would mean that you're legally responsible, but having a guardian's signature on an apartment means that you're authorizing that decision to move forward. It does not mean that you're co-signing. Guardians do not have any financial responsibility to the person under guardianship or any debt that they acquire. Number 6 is supervisory authority. So this is who a person spends time with. The idea behind this one is if a person is not able to see that a person is directly abusing them, the guardian is able to say, I see that this person is abusing you, and I'm going to say that that the contact that you have with this person has to stop now. This is distinctly different than not liking somebody's friends or girlfriend or boyfriend or however it be. This has to be backed by proof and has to be proven to a court that this person has intent and availability to abuse, harm, neglect a person. And then finally, accessing government benefits. So this is getting access to Social Security or to medical assistance or talking with the county. Again, this could be a great way for a release of information to work as an alternative, because if sometimes I personally don't have a guardian, but sometimes I'll get a letter from my insurance company and I'll have no idea what to do. And I'll still have to call my mom or a friend who works in that business too. So this is a hard one as well. People can continue to get supports in this area, but accessing government benefits, that is as well a power of guardianship. So to reiterate, the full guardianship is if a person needs support in all of these areas. A limited guardianship is if a person needs support in just a few of these areas. And you can pick and choose exactly and only what a person needs. So it could be 1, 4, and 6, or it could be 2, 4, and 7, or however that works. And the areas that a person doesn't need guardianship powers in, they may still need support in, like determining the place of abode. That may not be necessary to take as a power of guardianship, but the person may still need help in that area. So that's when you can utilize those less restrictive alternatives to support that person as well. There's a few questions. If you could please email, I can definitely email that attorney list to the person that requested it. Anybody else, go ahead and email me directly, aliciawolf@arcminnesota.org, or leave a note and I can get that to you. How do you request a full guardianship versus a limited guardianship in court in Minnesota? That's a great question. So when you are having a conversation with the attorney, that is when you would mention that you want it to be a less restrictive or a limited guardianship or a full guardianship. Because so the first step is to learn about your guardianship options. That's the first step in all of this, is to watch this webinar and learn about your guardianship options, have the conversation with your family, see what is the best decision at that time for your loved one, and then determine powers of guardianship, alternatives, how that's all going to work out. And then The next step would be calling an attorney. If you decide that the person needs one or all of the guardianship powers, you would call an attorney, and then you would start creating that petition for guardianship. And that petition is going to explain why a person needs guardianship. So at that time when you're working with the attorney. Any other questions, please keep them coming in. The rights of the individual, civil and constitutional rights are retained unless otherwise removed by the court. So this means that people under guardianship still have a Bill of Rights. There's a Bill of Rights in Minnesota state statute that lists all the rights that a person has under guardianship. And this includes everything from the right to be treated with dignity and respect to the right to privacy. The right to vote is on there. Courts now are asking in the guardianship hearings if a person can retain the right to vote. And if a person can definitely still retain that right to vote, because that is a right that people should have whenever is possible. And additionally, rights of an individual is the right to get married and procreate. Regardless of guardianship, that is a right of an individual unless otherwise removed by the court. A guardian cannot, without a judge's approval, a guardian cannot make a decision about medications that are not approved by the FDA. A guardian cannot authorize a sterilization of an individual as well. So that Bill of Rights is a great resource that you can look at as well. This is the full list of the Minnesota State Statute Bill of Rights. So as you can see, there's a lot of rights that people retain regardless of the level of guardianship. Any questions on this, please go ahead and type those in or ask later. The role of the guardian. So as a guardian of a person, it is your job to ensure the health, safety, and welfare of a person. So this means that the court is giving you the responsibility to make decisions on behalf of another person that's going to ensure their health, safety, and welfare. And additionally, it's your job to be person-centered in those guardianship decisions. And person-centered is a term that's getting tossed around a lot in disability services right now, but this just basically means that people have ideas and dreams and hopes for their life. And as guardian, even though it's your job to make sure that somebody is healthy and safe and has good welfare, it is your job also to make sure that they're living the life of their choosing and that they're living a good, happy life. And sometimes the decisions of a guardian aren't always going to be the easiest decisions to make. Like, let's say that somebody wants to live in Coon Rapids, and you're saying, well, you grew up in Minneapolis, your whole life is in Minneapolis, all of those services and supports are in Minneapolis. It's your job as a guardian to have that conversation and to entertain that idea of why the person wants to live in Coon Rapids. What's the appeal of living in Coon Rapids? Could we actually make it happen? Because personally, I think we could all relate pieces of our lives and decisions that we've made that haven't necessarily been the quote-unquote best decisions. We've made decisions that have directly interfered with our health, safety, and welfare. And so to a certain degree, it's a guardian's decision to weigh the pros and cons and to make sure that a person, yes, has all of those things and all of those resources, but sometimes is also living a good life with a little bit of risk to it, because there's a lot of dignity in risk. We feel a lot of power when we can make good decisions about our life and sometimes learn from those mistakes as well. So the role of a guardian is to make sure the person is healthy and safe, but also happy. So one of the questions that we get fairly often is the court and attorney fees. Guardianship is a court process, so it's going to come with a lot of questions as to how much is this going to cost. I have to obtain an attorney. I have to go to court. So there is a resource called IFP. In most counties, they offer IFP, informa pauperis. It's an old Latin term, but basically it means that if the person with a disability is in poverty, then they can get IFP. And IFP is based solely off of the individual's income. So the individual's income is the only one that is considered. The parent's income is not considered when it comes to IFP. So if the person and the person alone is considered impoverished, then they're eligible for IFP. And IFP makes it so the court waives their court fees and will pay the attorney to do the petition and the work for you. So IFP, for people that live in counties that offer IFP, you can potentially have the guardianship process done for free if you are eligible. Usually if a person is on medical assistance or social security, they're automatically eligible for IFP. So that can be a really great resource to a lot of people. Something to note is that Ramsey County does not have this process. Ramsey County does not offer IFP to families. So families can work with an attorney that works off of a sliding fee scale or has payment plans, and people can also private pay. So you can private pay for the attorney to do the work for you and to go to court. As well, if a person has a special needs or supplemental needs trust established, then the money to pay for guardianship has to come out of those funds as well. These are the fees, the payment. If you do end up having to do a private pay for guardianship, it's usually anywhere from $1,000 to $2,000 is what is typically expected, depending on the attorney, of course, and the length of the process. So again, I kind of started talking about this before, but to reiterate, the process is to, number one, know your options, which you're doing right now by watching the webinar, and that's the pre-first step in the process, because it's not on that list, but that is a really crucial and really important part of the process, is to know your options and to know fully what you're getting into. I talked to a lot of guardians that say that they thought that guardianship was going to fix a lot of the issues that they were having in supporting their child, and it just doesn't, because it's not set up in that manner. Or guardians feel like they have more responsibility than they actually do, or less responsibility than they actually do. So the very first part of the process is knowing what your options are in guardianship and really understanding what the guardianship process is. Then if you decide to move forward with the guardianship and that it's needed, the first step is to obtain an attorney. Now we have that attorney list, and I'm more than happy to send that to anybody who requests it. With that attorney, you write a petition. And basically what you're doing is you're explaining to the court why you need those specific powers of guardianship of those 7. Remember, we walked through those 7. So you're explaining in the petition, out of those 7 that you're choosing, why that is absolutely needed. And you're also explaining why an alternative isn't a good enough support. So that's some things that you have to justify. After the petition is written, the attorney will send that into the court, which will prompt the court to set a court date and to schedule a visit from a court monitor. Now, this court monitor is going to come out and visit the person that is potentially going to be under guardianship. So the court monitor is going to read that person under guardianship the petition, which is why it's important, so important that the person under guardianship, or the person that needs support in making decisions, is an active part of this conversation, because they could be an active part of the conversation of, hey, is guardianship needed or not needed? Is it needed? Let's do a limited guardianship. Is a full guardianship needed? Because that court monitor is going to come out and read them the petition that was created with the attorney and ask how they feel about it. The person gets the court monitor, and they also get a court-appointed attorney. Now, these are safeguards that the court has set up, because taking somebody's decision-making rights away, well, it may be necessary for that person, is a really big, it's a big thing, and the court doesn't want to take it lightly. So the court monitor is one of those safeguards to come out and to talk to the person so that the judge has that information. The court-appointed attorney is there to stand up for the person if they need it. These are just the opportunities to make sure that our system is working for people and with people. After the visit from the court monitor is going to take notes on what that meeting was like, give that to the judge, and then you'll have your court date. This court date, it'll probably, the actual time that you'll be with the attorney, or with the judge, I mean, will probably be anywhere from 10 to 15 minutes. So it won't be an incredibly in-depth, long process, but the court date that you're there with an attorney, it'll be usually like 5 or 6 different families, maybe more, maybe less, that are called into a room all at the same time, and they're individually called to meet with the judge. So that's what you can kind of expect on the court day. And then at that time, if the judge grants guardianship, you'll then within a week or so, you'll get the letters of guardianship. Now, these letters of guardianship are really important. Make sure that you keep that original document, that you make copies, that you scan it in, you put it on an external hard drive, because you're going to need those little letters of guardianship. Because if you're taking the medical power of guardianship, then you'll want to share it with doctors' offices. If you're taking the care, comfort, and maintenance, which is the second power of guardianship, then you're going to want to share it with school. So just make sure that you are keeping record of that. And then finally is the annual reporting, which we will talk about next. There's a few questions that just came in, so I'm going to see if I can answer any of those right now. Somebody asked the monthly cost of a guardian. That's dependent on a lot of things. A lot of people, if a person is turning 18, a lot of times it's the caregivers or the parents that are stepping into that role, and they're not paid. They're an unpaid guardian. If a person needs a paid guardian, they can either choose somebody themselves who works as a professional paid guardian, or they can work with the courts. A court-appointed guardian is going to have a different price point than a private guardian. And I would recommend that you call myself or talk with the attorney that you start working with in what that process would, or how much that the person would cost, and what the pros and cons of that is. You can set up guardianship payments through a trust. Yes, you would have to talk with the trustee if there's one established to put that into the trust. Yeah, so thank you, Beth from the ARC in southeastern Minnesota. She said that some people can file the paperwork without an attorney. And can do it themselves. And this is definitely possible. People can go through this process and represent themselves. I recommend that people, if at all possible, seek out an attorney, especially one that offers an IFP rate, because guardianship attorneys can do the process really in their sleep. They know how to write those petitions. They know the court process. They know who to turn it into. And if you can get IFP in form of papyrus, where the attorney and the court fees are waived, then it really makes sense to have that support from an attorney, because then you're not guessing what paperwork to fill out or what to do. That attorney is supporting you at no direct out-of-pocket cost to you in that moment. So yes, people can represent themselves. If IFP is an option, that's why I recommend it, because it can be the least headache way to do it as well. So somebody asked about an ARC special needs trust. So I would recommend, for questions on the special needs, supplemental needs trust, and the pool trust, I would recommend that you watch the webinar that we have on our website right now, which will get updated soon within the next few months here. Same information, but we just want to make sure that our webinars are at least 6 months up to date. But that webinar will go through the intricacies of what a trust can pay for, what a trust cannot pay for, what a trust is, what the different kinds of trusts are. So I'd highly recommend that. Casey asked a question on if a conservator fees can be paid for through a trust, and yes, they can. Just something to note is that a guardianship is distinctly different than a conservatorship. About 10 to 15 years ago, this wasn't the case. The terms were more so used interchangeably, but now guardian is decisions for a person, and conservator is decisions over the estate. So again, guardianship is decisions for the person, what is happening in that person's life. Conservatorship is decisions over that person's estate. And the way that I talk about conservatorship is every situation is different, and I'm not an attorney, so I can't recommend what people do, but typically conservatorships are best suited for people that have a really large estate. So imagine somebody who has spent their lifetime with an estate or has comes from a lot of wealth, and maybe they're elderly and they're writing checks and not able to remember, so they're writing the same check day after day, or they're not able to manage their estate in general. That's when a conservator would be a good option for people. Being a conservator comes with a lot of reporting requirements. So if a person needs help with a small amount of money or needs help managing their Social Security, I would highly recommend a representative payee or an ABLE account or a special needs trust or a shared bank account before doing a conservatorship. So just know that those are distinctly different things. Okay, ongoing responsibilities. So thank you for submitting those questions. Please continue to do so. The ongoing responsibilities for guardianship. Let's say that you did a limited guardianship, you went through the court process, you got those guardianship papers on October 23rd. So that means every October 23rd, you have to submit an annual statement of well-being and a right to petition to the court. So every October 23rd, this is paperwork that you have to submit to the court saying that you are still acting as guardian. You believe that guardianship still needs to continue, and it's that annual report to say that you're still doing this work and it's still needed. Now, this annual report is, you're not going to get reminded. The court will not send you a reminder. Your attorney may. The attorney that helped you set up the petition and helped you establish the guardianship will probably remind you at least the first year, but the court currently does not remind people that this annual statement of well-being is required. So when you get those guardianship papers, make sure to mark on your calendar that this needs to be done every year. And it's every single year for as long as the guardianship exists. This paperwork is found on mncourts.gov. It's easy to find this if you go to mncourts.gov and then you click Help Topics and then click on Guardianship and Conservatorship. And then in the Forms, there's a Forms tab where you can get all of the forms that you need to establish a guardianship, change a guardianship, terminate a guardianship. The annual statement of well-being, the right to petition will be on there as well. So the annual statement of well-being is an accounting for how you have been a guardian and how the person under guardianship has been for the last year. So if you get guardianship on October 23rd of 2018, that means on October 23rd of 2019, the court is going to need the annual statement of well-being for the past year. So those are the dates that you are reporting to the court on how things have been. In this annual statement of well-being, you're saying how a person has been physically, how a person's mental health is going, how their job is going, how their social life is going, and what kind of support you've been giving to people. It'll ask you if the guardianship should continue. It'll ask if you're getting paid to be a guardian. So that's the annual statement of well-being that you would send to the court. I would highly, highly recommend that you make a copy of this before you send it in and keep it for your personal records. That way you have a copy of what you sent in, so you can remind yourself that that task is done. And then also you have something to base next year's report off of as well. You can't use the exact same report year after year. You can't use the exact same language, but you can use it as a template. So if it's you filling out again next year, you can use it as a guide for yourself, or if somebody else is in the position to fill it out as well. Now, the right to petition is a letter that you give to the person under guardianship and any other interested parties saying that, hey, if there's anything in this guardianship that you want to change or that you disagree with, you have that right. You have the right to petition the change in guardianship. So here's the information for the court and how you get a hold of them. So you are required as guardian to do that annual statement of well-being and to give the person the right to petition. There's also an affidavit in there that says, yes, I as guardian gave the right to petition to these people. So the court is going to get all of that paperwork ongoing. This is only 3 pages. So this is a fairly easy thing to do annually. In the first year, again, your attorney that helped you set up the guardianship would likely send you this information and give you kind of a guide to work through it. And as well, the ARC can always support families in knowing what needs to be in that annual statement of well-being and how to fill it out. So these are some resources that I like to give to people as they're considering guardianship resources and different supports. The ARC Minnesota, we have our ARC guide to guardianship. ARC guides are when we take a really complex system or support and we break it down into a 1 or 2 page explanation. So our ARC guide goes more into depth about the alternatives to guardianship that you can consider and the different powers of guardianship, as well as the process. So there's information on there. The practical tool was created by the American Bar Association, and this is for attorneys, but I think that it's a great tool for everybody. The practical tool, it's an acronym, of course, but practical stands for, each letter is a different thought, a different process that you can engage in to think about, is a guardianship really needed or should we go with alternatives? So that could be a good resource, whether you're an attorney or a professional or a parent. That could be a good way for you to consider if an alternative is better than a permanent guardianship. The Minnesota Association for Guardianship and Conservatorship is the professional organization that gives information and changing standards and updates to professionals that work in guardianship and conservatorship. The Bill of Rights for people is on there, and if you wanted to get in touch with a professional, like a professional guardian or conservator or fiduciary, that could be a good resource as well. Supporteddecisionmaking.org is one that I had mentioned earlier in this presentation. This website is wonderful for people that are wondering how a supported decision-making agreement or how alternatives could work. You know, how have other people, how have other families done this and made it work for them? So that can be a good place to go for a resource. mncourts.gov is where I was telling you can find all the forms, information. Before you go through a guardianship, you're required to watch a video. This is where that video is at. It's fairly easy to access, but that is the direct link as well. So those are the resources. Another question came in, so I'm going to go ahead and read that. Please continue to type up those questions and send them in. Before we move on, thank you so much for being here and listening to this webinar and tuning in. I think it's really important that families and professionals and caregivers know that there are options in decision making, and guardianship and alternatives are unique and work differently for each person. Yes, so thank you. George asked, could you talk about the about co-guardians and the pros and cons of that as well? So you can, when you establish a guardian, there can be 1 guardian, there can be 2 guardians, or there can be 3 guardians. I've never really seen more than 3 guardians. I'm sure it's happened, but the courts don't like to do it because that's a lot of people making decisions. So the pros of co-guardianship is that shared responsibility, that more than one person is there to support somebody in making decisions about their life. There's also the consideration, though, that all of those people virtually have to agree on what that decision is. So if there's 2 guardians and those 2 guardians greatly differ on where the person lives, then a decision can't be made until they both agree. So that can be something to consider. But that also means that with 2 guardians, that means that one person, if you can't get a hold of one guardian, the other person can be there to make a decision. Additionally, a lot of times I see it's 2 parents, so a mom and a dad, that are co-guardians of their son or daughter. And it may be that way for 10, 15, 20 years. And then as the parents age, they want to add another adult sibling to that. I think that's a great idea. I would highly recommend that, because then the adult sibling can act as a guardian and get support from their parents before somebody passes away and before it's before you're going through the grieving process, and it would just make it much harder. So having co-guardians can be good, because then if somebody were to suddenly pass away, then there's a co-guardian there to make decisions, and there's not the necessarily the impact of being under guardianship and not having a guardian. So that can be a struggle. I would say that co-guardians are a great idea, but the thing that is really, really important to consider is the decision-making abilities that those two people have to be able to make together. Because the court is not going to say, okay, this guardian is going to make decisions about the person's home and benefits, and this person is going to make decisions about their health and their job. The co-guardians are co-guardians for all of those different areas. So that is definitely something to consider. Next question, I'll read now. Okay, so this person asked, somebody asked, what if the person contests the guardianship? Now, contesting the guardianship means fighting the guardianship or telling the court that they don't want it anymore. So what if the person contests the guardianship, saying that they are not incapacitated, yet they're on the verge of being evicted and had utilities shut off? So this is why it's a court process, because it's the judge's decision then. So if a person's under guardianship and they say, hey, I don't want a guardian anymore, I'm going to go back to court and I'm going to try to terminate the guardianship altogether. The judge is going to look at if that's the best decision for the person. So if the judge gets a bunch of information and the judge sees that this person is getting evicted, that they've had their utilities shut off, et cetera, but the person is saying that they want to be their own guardian, that's up to the judge to decide. That's the court process. So the judge is going to consider, does this person have the level of need to still continue to warrant a guardianship? Or is this a decision that, you know, maybe it's not based off of their disability or based off of their incapacity. Maybe they need support, but they don't necessarily need the level of guardianship. So if a person is going through to contest the guardianship and their family is concerned about that, I would recommend that they make sure that they have evidence to the judge that the judge needs to make the best decision. There's a lot of people that are under guardianship that don't need a guardianship as well, and so a lot of times that a good benefit can be professionals and loved ones supporting them and giving information to the judge as to why it should be one way or the other. Okay, I'll read the next question. If you have a co-guardian, do you both need to sign paperwork for signing a lease? So for the legality of that question, I'm going to refer you to talk to an attorney, because I've seen it both ways. I've seen it where just one guardian signature is enough to be able to warrant that decision, and sometimes depending on the provider and depending on the legality of the situation, sometimes they need to. The annual report of well-being definitely needs to be signed by both guardians, or each guardian, if there's a co-guardian, or each guardian would need to submit a separate report. Peggy, I don't quite understand your question. If you would like to retype it. Yep, so somebody had asked if there's co-guardians, if everybody that is a co-guardian needs to do the annual report. Yes. So let's say that it's two divorced parents, and the two divorced parents are working well together to make decisions and to be co-guardians. Let's say they live in different states. They can each separately file an annual report of well-being, or they can create an annual report of well-being together, sign it, date it, send it in within one document. Okay, so I think that that's actually all the questions that I'm able to answer right now in the moment. Overall, for guardianship, I want people to know that there are options in decision making. There's no one right way or one wrong way. Guardians are not financially responsible. You can have co-guardians. Guardians are required to make decisions in a person-centered manner and honor the person and what they want. Guardians are ultimately responsible to the court. It's the court's decision to grant a guardianship or to terminate a guardianship. If you would like a real in-depth assessment of whether a guardianship is needed or not, Volunteers of America does that. Volunteers of America, the Center for Excellence in Supportive Decision Making, can sit down with people and create a plan and really establish what decisions a person needs guardianship over and what they don't. The ARC as well, we have our ARC Guide to Guardianship. We have these webinars. You can call at any time and discuss all of the intricacies as well. So that is all of the questions that I have come in today. We will end here. Thank you all for tuning in and being a part of this webinar. It will be posted to YouTube shortly as soon as we can upload it. I hope you all have a wonderful day. Thank you for tuning in.